PJ. I hope you're all having a nice afternoon. I'm coming to you from Leesburg, Virginia, about 30 miles northwest of Washington. It's 60 degrees outside, really beautiful. I hope it's nice wherever you are. Okay, before we start, if you could mute your microphones, that would be great. Also, there's a chat box down here. If you have questions during the talk, go ahead and post them there. At the end of the talk, we'll have a little session where we can do a question and answer period. So we have a fantastic speaker for you this afternoon. David O. Taylor is Professor of Law and Robert G. Story Distinguished Faculty Fellow at the SMU Dedman School of Law in Dallas, Texas. He also founded and serves as the director of the school's Tsai Center of Law, Science and Innovation. Professor Taylor earned his Bachelor of Science in Mechanical Engineering from Texas A&M and his Juris Doctor from Harvard Law School. After graduating from law school, Professor Taylor clerked for the Honorable Sharon Prost of the Federal Circuit. Professor Taylor is the inaugural speaker of the AAPJ's new speaker series. So we're planning on inviting other distinguished leaders in academia to come talk to us in the future. I don't know, maybe every couple of months, we'll see. So after you hear Professor Taylor, let us know what you think. Also, this speaker series is in honor of Pasquale Joseph Federico, a member of the board from 1947 to 1970. He is best known for drafting with Judge Giles Rich the 1952 Patent Act, but he's also known as a scholar. And I think Professor Taylor is a deserving inaugural speaker, a scholar in the footsteps of Pat Federico. Professor Taylor, the virtual floor is yours.
Well, thank you. Wow, that is an enormous shoes to fill, PJ Federico. So I really appreciate that introduction. And I do have a presentation. I'll share my PowerPoint presentation now, so that we're on the same page, and hopefully you can see that. So one of the things I like to focus on in my research is the Federal Circuit. And so what I want to talk about today is really the relationship between the PTAB and the Federal Circuit, and really to what extent the PTAB and its creation and its work has impacted the Federal Circuit. And I want to do that in a couple of ways, but before we do that, this is really what I call institutional choice. It's a matter of institutional choice. I teach a class on this. It's the idea that Congress got to create. They created the Federal Circuit, which, as we all know, is very unique in the federal system. Created the PTAB. We had the Board of Patent Appeals and Interferences. We now have the PTAB. But it was a choice of Congress and the presidents at the different times. But it's a matter of choice, and we could change it. And things are always in flux, and maybe it'll change, and aspects of it will change. But I wanted to study the way that Congress and the presidents have created the patent system now. I wanted to analyze that in really two ways. One, through taking a second look at case law, and then also I wanted to look at data. And so I'll kind of break up my presentation into those two parts. So the background here, I think everybody knows this, but just to set the stage, the Federal Circuit was created in 1981. It started its work in 1982. It's really a very recent creation in our patent system, if you think about it. And I think studying the legislative history, reading the reports, you'll find, I think, two primary reasons the Federal Circuit was created. One was to create some uniformity in patent law. The Supreme Court was not resolving circuit splits, and so we had the creation of the Federal Circuit to have one set of patent law that would apply nationwide. And then as well, and this was not so much expressed in the reports, but kind of you read between the lines, you remember stagflation. Maybe we're getting into stagflation, I don't know now, but sadly. But certainly in the late 1970s, early 1980s, the Federal Circuit was viewed as a way to strengthen the patent system and strengthen the economy. But let me just highlight, in both respects, the creation of uniformity and the strengthening of the patent system, my reading of the history here is that Congress, and at the time it was President Reagan, were seeking to remedy problems with the patent system that were ostensibly caused by the Federal Circuit. Refused to resolve circuit splits. Some aspects of its law were not very favorable to patents. So then, of course, we had the AIA. We're all familiar with that. So let me cut to the chase on that. I'm focused here, of course, on the creation of the PTAB. And I think there were two primary reasons Congress and President Obama created the PTAB. One was to reduce the cost associated with invalidity disputes, to get those out of federal court and into an administrative body. that had some expertise as well. Maybe we should add expertise here as well. But with all of this idea that we want to improve patent quality, that's the good way to talk about it. Some people like criticize, oh, it was an effort to invalidate patents. I wouldn't call it that. Improve patent quality. Make sure that issued patents conform to the requirements of the patent statute. But for this, remember, it's a choice. And I think in this respect, my reading of the history here is that the government was responding to problems with the other avenues to address the validity of patents. District court litigation, for example, as well as the prior forms of review at the Patent Office. And so if you think about it, the Federal Circuit and the PTAB were created at different times, obviously, but really to address different problems. The Federal Circuit seemingly was created to strengthen patents. And you might, and I mentioned this as kind of the critical way, it's not really the way I think about it, but you might say, well, the PTAB was created to make it easier to invalidate patents, or at least easier to have a procedural mechanism and a second look at making sure patents qualify under the patentability requirements. But effectively, with the creation of the PTAB, we really have a new patent system. And so I wanted to study this new patent system, and it's a new system. Interestingly enough, the Federal Circuit and the PTAB, right? You that are currently judges, you write opinions. Those get reviewed by the Federal Circuit, of course. The Federal Circuit opinions, I'm sure you read and you take very much interest in those. It's an avenue for really communication between these two sets of judges. So I wanted to look at the cases, both in terms of a certain set of cases I'm going to talk about in a second, but also some data to analyze, now that we have the PTAB, how has it impacted the patent system and the Federal Circuit in particular? So I'm going to, these cases, but I want to take kind of a high level review of, as it turns out, the Supreme Court's decisions in patent cases that relate to the PTAB. And so I wanted to take more, collect all of those cases and think, are there any trends that we can identify? And again, now I'm going to the Supreme Court, but I wanted to look at important cases decided by the Federal Circuit when the Federal Circuit was thinking about the PTAB and its authority, statutory authority, its place in the constitutional system, its rules and procedures. And I thought, well, what are the important cases? Well, every case is important to the litigants, but the Supreme Court, by taking these particular cases, the Supreme Court thought those were important cases. So I said, okay, that's fine. Let's look at those cases the Supreme Court reviewed, where it was reviewing the Federal Circuit's decision-making with respect to the PTAB. So going down the line. So oil states, right? I kind of start with that. It's the big case, right? Article 3, is the PTAB going to continue to exist effectively? You might think of it that way. Or must these disputes be resolved in court? And so what I wanted to highlight is the Federal Circuit, I've underlined it here for a point, the Federal Circuit did not act as a roadblock. The Supreme Court decided there was no violation of this Constitution. It did not violate Article 3 to have non-Article 3 judges deciding validity disputes. But I wanted to highlight the Federal Circuit reached the same conclusion in a different case. And so the Federal Circuit did not act as a roadblock to the PTAB taking its place as an administrative body with authority to review the validity of issued patents. So we know Arthrex. I know you, who are active judges, know Arthrex very well. So I'll cut to the chase on that opinion as well. Remember, it was the Supreme Court that limited the PTAB's authority by shifting some authority from the PTAB to the director of the Patent Office. It was not the Federal Circuit that did that. It was the Supreme Court. So again, taking a very high level analysis, it wasn't the Federal Circuit that acted as a roadblock or prevented the PTAB from having significant authority. If anything, it was the Supreme Court, I guess, but the Federal Circuit was receptive to the PTAB having significant authority. Okay, let's go to Quozo, right? And by the way, now I'm shifting from constitutional challenges to statutory interpretation. Okay, so there's different cases with different aspects of the law involved. But now as we switch to statutory interpretation, in Quozo, you remember Quozo, I think it was one of the first cases of the Supreme Court reviewing the Federal Circuit's decisions related to the PTAB's authority. And in that case, the Supreme Court, will remember, said, look, there's a bar of judicial review, at least in this type of case, there's no judicial review of decisions to institute inter partes review. What I'm highlighting here, though, is the Federal Circuit reached the same result. Okay, in other words, if we focus on this high level question, the Federal Circuit again was respecting the authority of the PTAB. It was not taking an act to gather more power unto itself to review PTAB decisions on institution. So in some sense, as I say here, that insulated the PTAB, or if you want to think about it, increased the power of the PTAB because its decisions were not going to be reviewed. And by the way, in the criticisms of the Federal Circuit, I'll come back to this hopefully in the end, but the criticisms of the Federal Circuit over its history have been that it views itself as an expert body, and therefore in its various relationships, even with the Supreme Court, but certainly with district courts and even with the Patent Office, it tries to assert its authority to decide matters that perhaps under a strict reading of the law it should not. So for example, in claim construction with district courts, this idea of de novo review, although now I guess it's the test, we have a little bit of fact, some fact issues can be in claim construction. But anyways, in that context, the criticism of the Federal Circuit is it tries to assert itself and decide more issues, not defer to the district courts. Well, similarly, there's been criticism over time with respect to the Federal Circuit and its relationship with the Patent Office, that the Federal Circuit tends to view itself as the expert and sort of reject any expertise by the Patent Office. And at least in these several respects, we have not seen that. We've seen the Federal Circuit almost welcoming kind of the PTAB with open arms to some extent. Okay, SAS Institute, you remember this? The Supreme Court took this case and said that the Patent Office cannot curate the claims. It must, it can't curate, it can't pick and choose which claims, it has to take all of them or none. I just want to highlight the Federal Circuit had held the opposite, right? Agreeing with the PTAB that it did not need to take all or deny all. It could pick and choose. So interestingly enough, the Federal Circuit had deferred to the PTAB's practice, again, which as a result gave the PTAB significant discretion. So we're seeing a theme, I hope, right? So then return mail, let's talk about return mail. Again, we're seeing the same theme here. The PTAB had decided that the Postal Service could file a petition and it would be a live petition. Supreme Court ultimately said no, but again, focusing on the Federal Circuit, it had agreed with the PTAB that a person does not exclude the government. So again, we see the Federal Circuit agreeing with the PTAB, but also in a way that expands the scope of the lower courts, the PTAB's jurisdiction. So the PTAB would have more jurisdiction because it could review petitions filed by the Postal Service or other government entities. All right, so another case of statutory interpretation, Thrive. In this case, this is about time bar determinations. You may remember this one. The Supreme Court reversed the Federal Circuit. The Federal Circuit had actually cited another holding in another case, but had reached the conclusion that time bar determinations are appealable. So this is really the first time in all of these series of cases we're seeing the Federal Circuit taking a position that increased its own authority and over the PTAB. Okay, and so they wanted to be able to review these determinations. The Federal Circuit maybe not wanted to. They decided they had the authority to review these determinations, but in this case, Supreme Court disagreed. But the Federal Circuit, really for the first time in my list of cases, was taking a position that expanded its own jurisdiction, expanded its own oversight over the PTAB. Real quickly talk about the PTAB's rules, right? Going back to Quozo, there were two issues that went up to the Supreme Court in Quozo. If you remember in Quozo, back then, the idea was the PTAB had adopted the view that its constructions would be the broadest reasonable construction. That was challenged. The Federal Circuit and the Supreme Court said that's okay. If that's what you want to do, that's permissible. And so now we're flipping back to what we've seen being the common theme, except for the one case, is the Federal Circuit recognized the authority of the PTAB and sort of deferred to its, I'm going to call this rules. Okay, so the Supreme Court's decisions in cases involving the PTAB are not the only way we can highlight really important Federal Circuit opinions reviewing the PTAB. But as you know, the mine run is what I call it, the mine run of appeals of PTAB decisions to the Federal Circuit they're reviewing anticipation or obviousness, they're analyzing disclosure of prior art, maybe disputes over claim construction. In my view, these are largely fact-bound. It's not too often the Federal Circuit's interpreting the law or making, there may be some issues of law, but they're often very bound to that particular case. Like claim construction may be an issue of law, but it's bound to that particular patent and the particular evidence. You just don't very often, at least, see weighty matters of, for example, statutory interpretation, where the Federal Circuit's going to interpret the statute. There are exceptions, though, and so I'm going to highlight one: the Facebook versus Windy City decision by the Federal Circuit. So if you remember, it's a little dated now. It's about the, I'm calling it it's the Presidential Opinion Panel, POP. I call it the POP panel, even though two P's, it's panel is kind of repetitive, but the POP panel. Remember, in this court, the Federal Circuit was considering arguments that the POP panel did not have authority to interpret statutes, or at least the Federal Circuit did not need to defer to the PTO's interpretation of the statute. And the Federal Circuit, that's what the panel concluded. And this related to what everybody really cares about now, joinder and issues like that. But the important point here, and I've got several slides on this, I'm just going to, in light of time, kind of click through here. But the important point here is that the Federal Circuit did not defer to the POP panel because the dispute was over statutory interpretation. Okay. For statutory interpretation, there's kind of a line in the sand. The Federal Circuit was not going to defer. And in various respects, the court articulated rejecting essentially arguments that it should defer. No, nothing in the AIA displaces our obligation. We have the Administrative Procedure Act. There's really not notice and comment rulemaking in the way that would require us to defer. And by the way, this all refers to Chevron deference. That was the main issue, but also even Skidmore deference, if you want to get into administrative law. The Federal Circuit rejected the idea that it would need to apply Skidmore deference. So the bottom line here, cut to the point, the Federal Circuit and its judges found reason neither to give Chevron deference nor Skidmore deference to the POP panel. But it was with respect to questions of law, and it was interpretations of the patent statute. So there's a definite kind of line in the sand at that point. Okay, so my high level conclusions based on at least this analysis. I think the Federal Circuit actually has shown remarkable acceptance of the authority of the PTAB with respect to its role in adjudicating validity of patents. And there are a couple of exceptions. The Federal Circuit's interpreted the Constitution, statutes, the rules, giving great deference, supporting broad authority of the PTAB. That said, this line in the sand, the Federal Circuit, however, like I said, has not shown deference to interpretations of the patent statute. Okay, so that's where the line is drawn. Okay, so that's the cases. So then I wanted to transition and tried to go relatively quickly through that so we could get to some data. I know, it's patent judges, right? We want to look at some data. So what I did is I've looked at the data for even more than 10 years, but we'll see. I'll throw out some charts. We'll talk about it. So what did I do? I reviewed some coding. We did some coding of opinions. And what I wanted to do is look, I'm focused, by the way, on the Federal Circuit, not the PTAB's opinions. The Federal Circuit's opinions reviewing decisions of the PTAB, okay? And I think this shows and exposes the impact of the PTAB and its creation on the Federal Circuit itself. So I'm going to start on this slide, at least give you the data, and then I'll have my comments. And after this, I'll kind of switch around. I'll tell you my kind of analysis, then I'll show you the data supporting it. So you're going to see some data here. On the left, it's Federal Circuit total dispositions by opinions and Rule 36 judgments. By the way, it's from 2015 to 2020. We get like a 16-year snapshot of the work. And obviously it's sort of right in the middle, right? 2012, 2013, I think actually was the first year of any PTAB as opposed to BPAI decisions reaching the Federal Circuit. In other words, Federal Circuit issuing an opinion reviewing the work of the PTAB. So it's sort of the first half BPAI, second half PTAB. But on the left, it's Federal Circuit's total dispositions, all cases, whether it's district courts, Court of International Trade, MSPB, all of its cases. So you'll, of course, kind of look at the right to focus on I'll call these administrative patent cases, but BPAI and PTAB dispositions. So at the top, these are all other. So now I've segregated. The red line is the administrative patent opinions in Rule 36 judgments. Rule 36, by the way, is a summary affirmance by the Federal Circuit. You guys know that probably. That's what you dream of when they're reviewing your cases. But here on the bottom, right, is the administrative patent cases, and at the top is all other dispositions. So what you're going to see, really, if you focus on 2012, you're going to see before that it kind of varied, but there's a little bit of a trend line going down for all other dispositions, and there's certainly a trend line going up after 2012 with respect to the Federal Circuit's work. Okay, so what does this mean? The creation of the PTAB, if you look at the data, marginally increased the overall number of cases decided by the Federal Circuit. But if you just focus on the overall number of cases, you miss the point, right? When you separate the administrative patent cases from all other cases, you see that the Federal Circuit's busier, but the proportion of its work devoted to administrative patent appeals is much greater than it was prior to the creation of the PTAB. You guys are generating a lot of work for the Federal Circuit, in other words. So it's just one data point. Then in 2012, the percentage of administrative patent cases as compared to all cases decided by the Federal Circuit was just 12%. In 2020, the full year, it was 28%. So we have kind of a step up in workload in these administrative patent cases. By the way, these numbers are pretty striking to me, but I don't think they tell the whole story, because if you talk to Federal Circuit judges, you hear them speak at different conferences, they will say patent appeals are more complex than other types of appeals. And if this complexity, if what they mean is administrative patent appeals, not just appeals of patent cases from district courts, district court patent cases are probably more complex because they would involve invalidity, infringement, damages potentially. At any rate, so yes, the percentage of administrative patent cases is greater, the number of cases is greater, but if these types of cases are more complex than other types of cases, then it's not just that they're busier, they're much busier, and just counting the number of cases may not tell the whole story. Okay, so I again looked at the data and I thought to myself, well, how has the Federal Circuit dealt with this increased workload, both in terms of the raw number of cases, the percentage of administrative patent cases to the extent they're more complex, just the complexity of its cases. And I think one of the ways they dealt with that is summary affirmances. Again, making the patent judges happy when they see those. I'm not sure how closely you track your cases that get appealed, but anyways, so I looked at the data. The data shows the Federal Circuit more often grants summary affirmances in administrative patent appeals as compared to all other types of appeals. So that's an interesting point. The data, moreover, supports the idea that there are substantially more, as just a matter of numbers, summary affirmances after the creation of the PTAB. That said, there's more cases, right? Okay. So that's the next point, right? There's a greater number of summary affirmances, but there's also a greater number of cases. But as it turns out, when you actually look at those, the relative use of summary affirmances in administrative patent appeals did increase with the creation of the PTAB. Okay, let me show you this. So I wanted to tell you all that before we looked at this slide. So yeah, so on this slide, on the left, the Federal Circuit, and I apologize that the colors turned out to be the same. It's unfortunate, but this trend line here, of course, is the PTAB. They both look blue to me, but the PTAB opinions, which of course don't exist until 2013, then shoot up here. And by the way, these are Federal Circuit summary affirmances and opinions. Okay, so right here we have this transition between BPAI, those were dying out, and then we had the PTAB, the Federal Circuit's review of PTAB decisions. So what I want to highlight, it's fairly complex, but I want to highlight a couple of things. If you look at this, it's tan on my screen, but this right over here, when the Federal Circuit was reviewing the BPAI, the summary affirmances of the BPAI decisions occurred less often than the Federal Circuit issued opinions in those cases. Okay, oh, let me go back. So that you can see that because this kind of tan line is below the blue line. Now, if you start in 2012 there and you look starting in 2012 and going to the right, the red line versus the blue line, it's interesting. Between 2012 and 2016, the red line's above the blue line. What does that mean? Summary affirmances outnumbered the opinions issued by the Federal Circuit in PTAB decisions when reviewing PTAB decisions. So for the BPAI, the Federal Circuit issued more opinions more often. For the PTAB, at least initially, the Federal Circuit issued summary affirmances more often. Noticeably, though, that changed in 2017 and then more dramatically in 2020. Okay, and on the right, I have all other Federal Circuit, just to give you kind of a comparison data point, what the Federal Circuit's doing in all other types of cases in terms of Rule 36 summary affirmances and opinions. Okay, so that's interesting, right? So I want to come back to this 2017. That stood out to me. What happened in 2017? What happened in 2020? If you look at the chart on the previous screen, I tried to highlight it. What I was highlighting was in 2017, summary affirmances dropped dramatically at the Federal Circuit. What happened? Well, we lived through that time period. Some of you may remember. I think if you look back, you'll find that there started to be criticisms of the Federal Circuit issuing summary affirmances, and the criticism started in 2017. There was arguments that it was improper, it was violated statutory authority. Anyways, general criticism over use of summary affirmances. We need written opinions to give us guidance. Maybe it's the Federal Circuit responding to criticism. What I also want to highlight, and then I looked at 2020, let me go back to the previous slide, dramatically dropped in 2020 the use of summary affirmances. What went on there? Well, I've been studying the Supreme Court petitions challenging Federal Circuit decision-making. And if you go back and look, there were petitions filed at the Supreme Court in late 2019 and early 2020 challenging the Federal Circuit's use of summary affirmances in these PTAB cases. And at least it's my sense, or at least supposition, that the Federal Circuit recognized the criticisms, recognized that this was being challenged, and decreased the use of summary affirmances. Okay, whatever the cause, the reality is, though, the Federal Circuit still grants a significant number of summary affirmances as an absolute number, but also relative to the number of dispositions in these cases. So there's a lot of summary affirmances at the Federal Circuit. Okay, so most recently, the Federal Circuit has reduced its relative use of summary affirmances, but that begged to me at least the follow-up question: if it's not summarily affirming, what is it doing? And really, there's two options, I think, a non-precedential opinion or a precedential opinion. So I've pulled the data. In PTAB cases, is the Federal Circuit issuing non-precedential opinions, precedential opinions? What are the opinions it's issuing? So bottom line, since 2016, right, so focused on 2017 through 2020, the Federal Circuit substantially increased the number and relative use of non-precedential opinions to dispose of these administrative patent appeals. So decrease the use of summary affirmances, but then increase the use of non-precedential opinions. So here's the data to support that. Again, kind of focused here on the right side of the chart. You notice, again, this light tan, at least on my screen, PTAB non-precedential opinions as compared to precedential opinions. For the first few years, the number of non-precedential opinions slightly outnumbered the number of precedential opinions, but then after 2016, it really shot up. It really shot up, and the non-precedential opinions, at least 2020, were significantly more than the precedential opinions. So at least one interpretation of the data is that the Federal Circuit, responding to criticism of summary affirmances, decreased the number of summary affirmances, but then thought these cases were easy to decide, didn't need to issue a precedential opinion, started issuing non-precedential opinions. And again, just for completeness and comparison over here on the right is all other Federal Circuit opinions, non-precedential and precedential. Okay, so, and then you guys really probably care about affirmance rates, but at any rate, I decided to also look at affirmance rates in non-precedential opinions. And I focus on what I call a simple affirmance rate, by which I mean, did the Federal Circuit simply affirm? In other words, affirmed, nothing else. Or did it affirm in part, vacate in part, remand, obviously reverse, dismiss, lots of possibilities here. But looking at simple affirmance versus any other type of disposition, which would at least include some sort of reversal or dismissal or vacating. So kind of starting with my thoughts on the data. The data shows that immediately after the introduction of the PTAB, the Federal Circuit's simple affirmance rates actually decreased, but in 1 year, but that appeared anomalous. Beginning in 2015, the simple affirmance rates, and again, it's in these non-precedential opinions. I'll come back to the precedential opinions. They returned to their pre-American Mints Act levels. You know, it varied every year. We're going to see that between 61 and 79% simple affirmance rate. So by the way, this compares favorably with the simple affirmance rates in all other non-precedential opinions and all other types of cases. The numbers are a little bit different, but they're fairly consistent. So here's the data if you want to look at it in more detail. Over on the left, I've got, you know, BPAI, and then I've got the PTAB. So starting over here in 2013, really get the PTAB, the Federal Circuit's decision in PTAB cases. So here's where very early in the PTAB's existence, the simple affirmance rate was not that high. And then since then, though, it's been fairly high. And then you can look over here at all other Federal Circuits, again, for comparison purposes. Look at how the Federal Circuit's handling all other types of cases with respect to its non-precedential opinions. Okay, so, and then well, what about the precedential opinions, right? I think it's predictable that the simple affirmance rate would be lower in a precedential opinion. If the Federal Circuit's going to reverse, I would think more often it would need to explain in a precedential opinion why it's reversing. At any rate, the simple affirmance rate is lower in precedential opinions, but it didn't vary that much with the introduction of the PTAB as compared to the simple affirmance rate in precedential opinions when the Federal Circuit was reviewing the BPAI. So the simple affirmance rate in administrative patent appeals has only been slightly higher than the simple affirmance rate in all other types of appeals in the precedential opinions. So here's the data. And again, I'll leave that up here for a second and we look at it. Fairly complicated, of course, but the same kind of colors. If you want to focus on the PTAB, it's this tan line right here. And simply affirming, the tan line is simply affirming in a precedential opinion. And this blue line here is not simply affirming, so any of the other types of results that you could have. And then what I wanted to highlight over here, this is what I was saying. It's actually not that different than every other type of case. So, all right, let me move along here. So then I thought, well, what about dissenting opinions? How often are judges dissenting in cases that the Federal Circuit decides that were originally decided by the PTAB? And I think it's more likely to find dissenting opinions in precedential opinions. So I focused on precedential opinions, focused on was there a dissenting opinion or not. Bottom line, the numbers don't reflect a significant change in the pattern of dissent. BPAI versus PTAB, fairly consistent. Moreover, with respect to all other types of cases, there's not that much of a difference. So this is one of those, not that much different, maybe not as interesting for that matter, but in some respect it is interesting, I think. So you can look here, BPAI and PTAB precedential opinions with and without dissents. So if you look back over here, apologize, the same color, but BPAI opinions with dissents would be red. This is a number, it's kind of a smaller number, so not as significant. But then over here, obviously the number of precedential opinions where the Federal Circuit's reviewing PTAB decisions, the number is much larger. So you're going to have a larger number of opinions without dissents and a larger number with dissents. And then here's all other cases just for comparison purposes. All right, keep checking the time here. I want to keep us on track. Last thing I did is kind of the overall, what I call the overall simple affirmance rate, not looking at just non-presidential opinions, not looking at just presidential, looking at everything. And so the bottom line points, the overall simple affirmance rate did not change greatly between the Federal Circuit's overall simple affirmance rate did not change that much between the time it was reviewing BPAI cases and the time it was reviewing PTAB cases. You can get more granular in the data here. Between 2005, it varied between 48 and 85%, with an overall simple affirmance rate of 74%. That's That's all other types of cases. When you look at the administrative patent cases, slightly higher at 81%. And here's the data on that. So on this slide, it's the overall simple affirmance rate in administrative patent appeals in red, and then the overall simple affirmance rate in all other types of cases in blue. So my takeaway from that is fairly consistent, not significantly different. So here's my conclusions based on the data. I think the data also tells a pretty interesting story about the impact of the PTAB on the Federal Circuit. So going back, thinking about my high level thoughts looking at the data, is that the creation of the PTAB made the Federal Circuit busier. It significantly increased the percentage of administrative patent appeals as a proportion of its total docket. It's focused more often on patent administrative cases than other types of cases than it was before. And again, those may be fairly complex cases. So it's made the Federal Circuit judges work maybe harder. On the merits, though, it seems to be affirming the PTAB at a similar rate compared to affirming the BPAI. The rate of dissenting opinions likewise is similar between the PTAB cases and the BPAI cases. And so, in short, since the introduction of the PTAB, the Federal Circuit is busier, but reaching, you might say, similar decisions on the merits. So the last thing I wanted to do before we get into like a discussion is sort of contextualize my thoughts into this idea of patent law and institutional choice. This idea of, the PTAB, the creation of the PTAB is again, this is a matter of choice. It's a political choice for the Congress and the president. The Federal Circuit itself is a political choice. And the Federal Circuit, like I mentioned earlier, I want to come back to this. This focus really is on the Federal Circuit, the PTAB's impact on the Federal Circuit, the Federal Circuit's overview of the PTAB. But the Federal Circuit is subject to criticism. Historically, it's criticized as being too specialized. It likes to call itself as a semi-specialized court. It has exclusive jurisdiction over patent cases, and at least as an intermediate appellate court in the federal system. But it also has, of course, jurisdiction over other types of cases. So it's not only patent cases. So in that sense, the judges will say, well, we're semi-specialized, but it's certainly specialized in handling these patent cases. And there's a professor who's focused on this idea of the Federal Circuit viewing itself as the expert court. And certainly I think this specialization, or at least semi-specialization, contributes to the Federal Circuit viewing itself as an expert tribunal over patent law. And I mentioned this earlier, but it's been criticized by because arguably it has not deferred appropriately to lower tribunals when appropriate. Maybe I should add to other tribunals, because there's also this thought that the Federal Circuit may not always follow the Supreme Court's dictates when it disagrees. Based on this idea, and the explanation might be that the Federal Circuit views itself as an expert tribunal, whereas the Supreme Court's not viewed as an expert tribunal in patent law, and so the Federal Circuit may push back against the Supreme Court, whereas district courts are not viewed as experts, don't have any specialization with respect to patent law, at least as a matter of the law. We have factual kind of specialization, as it turns out, in a couple of districts. But at any rate, the Federal Circuit may view itself as the specialized expert tribunal, and therefore it may influence the way it's deciding these cases and not deferring to the other tribunals, the PTAB in particular. But now that we have the PTAB, we can rethink that, I think. And so if we look at the cases, certainly going back and look at the cases, as I mentioned, we see repeatedly the Federal Circuit seems to be deferring to the PTAB, certainly with respect to its factual findings, procedural rules, but not with respect to its statutory interpretations. And I'm going to add my own normative comment here, and I think that's appropriate. It's the Federal Circuit's job as an Article III court to interpret the statute, and that's fine. But it's certainly deferring to the PTAB in pretty much every other way, as we expect and would hope. And then when we think about the data, what's interesting is the Federal Circuit, it was criticized as being specialized. I think it's even more specialized now as a result of the PTAB's expanded jurisdiction. What's interesting about that is now, I mean, the BPI was specialized, it had expertise, but it just didn't have that many cases. Now the PTAB is just as specialized or expert as the BPI, but it has more cases, more parties are bringing cases to it. it has expanded jurisdiction, new procedures, new mechanisms to influence, or just new ways to decide cases. But now we have the Federal Circuit with kind of a competitive expert body in the PTAB, but the PTAB in its use has actually made the Federal Circuit even more specialized because so many more of its cases are patent cases. And so I say here, this likely contributes, again, to the Federal Circuit's procedural as an expert tribunal, but there's certainly criticisms with specialization, which we could talk about. There's arguments of tunnel vision. By the way, these criticisms, these theories and criticisms would apply not just to the Federal Circuit, but would apply to the PTAB in the sense that there's a concern with capture if a court has limited jurisdiction and specialization, that its repeat players coming to that court are going to influence it and move the law or move its adjudication in one way. It develops its own lingo, way of talking about things that other people find strange and hard to understand. And for this example, I'll go back to the Federal Circuit and the teaching suggestion motivation to combine test that it had developed in its law. And then the Supreme Court, when it reviewed that, specifically Justice Scalia saying, that's just gobbledygook. Anyway, so there's criticisms, but interestingly enough, if we want to, if a historical criticism has been the Federal Circuit's too specialized, well, actually the PTAB has made the Federal Circuit even more specialized now. And so these criticisms may resonate even more. So with that, I believe that was my last slide on the merits. I'm going to stop sharing.
Okay, Professor, thank you so much. I'm going to give others a chance to post questions in the chat box. But, you know, while you were talking, I was thinking, this is something I really don't know much about, but when you go back to your slide 24 and you show this increase in the Rule 36 from about 2012 until 2017. And yeah, I remember that criticism. Yeah, I remember reading about that. But do you know logistically what happened in the federal circuit? I mean, the number of judges hasn't changed. I mean, the board has grown a lot to handle the workload. And they're getting that workload from us, and it jumped dramatically there. But the number of judges hasn't changed. So I wonder whether this increase in Rule 36 is just the sheer amount of work that's been put on them. And I wonder what happened in 2017 that all of a sudden they seem to be able to manage the workload a little better. Do you know?
Yeah, so at one point, I do know that when I clerked at the Federal Circuit, each of the judges had 3 clerks, and maybe somebody else on the call will know exactly what year, but at some point, the Federal Circuit went to 4 clerks. And so, I mean, that's a 33% increase in the ability of the judge, at least through their clerks, to get work done. I don't remember the exact year, but at any rate, yeah, the PTAB, the volume of cases increased dramatically. As I showed on one of my slides, the overall work since the creation of the PTAB increased. I do think one of their responses, you're right, they didn't increase the number of judges. They may have increased the number of clerks at one point. They did not increase the number of judges. That said, there is a larger number of senior judges. I don't know the exact numbers, but when I was clerking, I think it was maybe 3 senior judges, and we have more than that now. And those judges do some work, but really it's not a significant increase in the number of judges at all. But yeah, I think the summary affirmances was one way to handle the increased load. Then they got criticism. I know Dennis Crouch on the Pat Leo, he's a law professor. He published several blog posts criticizing the Federal Circuit for summary affirmances. And there are others that kind of, I don't know if he was the first, but other people criticized it. And the timing matches when the Federal Circuit dramatically decreased the number or the relative use of summary affirmances, but all they did was increase the number of non-precedential opinions. And then, like I said, 2019, 2020, when there were these petitions at the Supreme Court calling, not just in the popular press, but in cases, calling into question the use of summary affirmances, it decreased even more dramatically. So yeah, so that tells an interesting story, doesn't it?
It does. It does. I mean, when you look at how, you know, the change to the board, how many more judges we had to bring on to handle the workload. You would have thought with all the, I mean, trials are normally appealed in federal circuit. The workload they've received from us since 2012 is dramatic. And, you know, to keep up with the workload like we had to do, I would have expected big changes there in terms of the personnel, number of law clerks. Yeah. Well, that's fascinating. All right, thank you for that. Let me see if we have any questions in the chat box. I have one from Judge Morgan. He asks, according to your analysis, the Federal Circuit generally acts in ways that recognize the authority of the PTAB. The Federal Circuit has appellate jurisdiction over matters that come up from other bodies as well, such as the federal district courts in cases involving patents, trademark trial, ITC, Merit Protection Board. Have you been able to ascertain whether the Federal Circuit's relationship with these other bodies is comparable? That is, does the criticism that the Federal Circuit does not defer to lower tribunals when appropriate stem from differences in how the Federal Circuit relates to the PTAB and how the Federal Circuit relates to other bodies? And to the extent the relationship differs, do you have any theories as to what might be driving those differences?
Yeah, it's a very good question. So in my analysis, of course, setting aside the case law analysis, but in the data analysis, I tried to always include like all of the other cases that the Federal Circuit decides, which would group all of those other, you know, the Veterans Court, all of the other tribunals that the Federal Circuit reviews, just to see are there any significant differences. I pointed out a couple times some differences, but specifically with this issue of deference, I think you actually have to dig into the case law and get a sense and on the merits of these cases. The data only tells part of the story. I mean, are they granting summary affirmances? That tells you something. Simple affirmance rate will tell you something. I didn't tease out all of the different tribunals. I guess I could do that. I just didn't. I just kind of grouped everything else compared to the PTAB to make that comparison rather than comparing each and every tribunal that's reviewing. So I haven't done that analysis. I will say, though, that there's another law professor, Paul Gugliuzza, who is now at Temple. He has written some articles on the Federal Circuit and its lack of deference to the lower tribunals. And he has, I think, tried to dig more into the substance and the merits and looking at the different areas. And my memory is that he has seen the Federal Circuit fairly consistently not deferring, not just in the patent cases, not just with the PTAB, but kind of in multiple areas of the law that it handles. So it's maybe not a great story in that respect for the Federal Circuit.
Fantastic. Okay. Another question from Judge Carmichael, who was also a judge at the board. Does the existence of the PTAB reduce the number and complexity of appeals to the Federal Circuit from district courts?
Yeah, that's a great question, because I kind of highlighted that in my analysis when I said, well, the Federal Circuit judges consistently say patent cases are very complex. Out of all the cases we handle, they're the most complex. I think they're probably talking more about the district court cases than the cases they review from the PTAB, because as you know, the cases from the PTAB, you know, anticipation, obviousness, limited set of prior art. And the district court have every aspect of these patent cases, including infringement and damages and inequitable conduct and all those, not that those are, that's alleged very much anymore, but just all the possibilities, evidentiary questions. So I do think that the district court cases are more complex, but the question that doesn't answer the question. I haven't done a one-to-one comparison. For example, I think what you have to say is, with respect to this patent, has this PTAB adjudication eliminated or reduced any what otherwise would be parallel? Or in other words, is there parallel litigation involving these same patents? I mean, you could do it at a very high level way to say, well, let's look at the number of cases, but I'm not sure. I mean, there's other factors that go into, you know, impacting how many cases are filed. And so I think I haven't done it is my answer. I think to do that though, you would need to go on a more granular level and say, with respect to this patent, here's this PTAB proceeding. Is there a parallel district court proceeding or not? And then going back over time and seeing, has there been a change in that respect? So I hate to say it, but I have not done that. But I think it's a very good question, because, by the way, this has bothered me about the American Vents Act. I know the American Vents Act, one of the thoughts was the PTAB and the inter partes review in particular would reduce, it would be a mechanism to get these disputes out of federal district court. And I know this is a recurring issue with even the PTAB's rules on joinder, but it's a recurring issue. It's really not turned out that way. There's really seemingly a lot of parallel litigation going on. So the argument that it's going to reduce cost and it's going to create expertise, I think, is subject to substantial question at a minimum. And because we have so much parallel litigation going on. So yes, there's the PTAB proceeding, but then there's the parallel litigation. And to what extent has the district court litigation been simplified as a result of the PTAB? Because that'd be another way. Maybe it still would simplify if you could take matters out of the district court case. But my sense, I don't have data on this point, but my sense, attending presentations and talking to litigators, is it has not reduced the complexity of the district court litigation.
So if you do another study, will you come back?
For sure, yes. Yeah, it'd be great.
I have another question from Judge Giannetti. Your analysis suggests that the ability of the PTO to evaluate validity of issued patents began with the creation of the PTAB. But it really began in 1980 with ex parte reexamination. Have you done any comparisons between the two proceedings in their effect on the Federal Circuit decision-making?
That's a good point. No, if you go back and think in my slides, we can make them available to everybody, but I did not go back to 1980. I was really focused on the Federal Circuit, which of course started in 82, but even the data was not, I did not start in 82. I only went back. I'll tell you, what I did is I started with the data that was available, first of all. The database I used picked up the Federal Circuit's decision-making when the Federal Circuit started publishing its data to its website. And so I believe that was 94. I didn't grab all of the data. Effectively, what I did is I grabbed as many years prior to the creation of the PTAB as years I had of PTAB data. I just made a choice in that regard. So I did not go back, and I certainly did not focus on, was this an inter partes review? Was this a Federal Circuit review of an inter partes review proceeding? Was it a review of another type of proceeding? I have not done that as well. And I will tell you that there's I'm forgetting the name of it offhand, but the Jason Rantanen at the University of Iowa, he has, I think he calls it the Federal Circuit Compendium, I think that's what it's called. But Jason Rantanen, University of Iowa, he has a database, and part of the data I used was from his database. He has some law students that he supervises to help code. I have some law students that code in some respects. He has law students that code, and he has a pretty good repository. And the data is just much easier to gather. Once the Federal Circuit started publishing it on its website, we could just download it. And the Federal Circuit had already coded at least some basic information about the cases, and then we just add to the coding. And so that's the backstory.
Yeah, I know that database. I think there's an API that goes with that.
Right.
You can connect to. Yeah, very good. Very good. All right, that's great. Thank you, Professor. I have another question here. Question for the professor. You think that when the Federal Circuit has exercised its authority as expert of statutory construction, it has leaned on the side of reading the statute to give the court more power of oversight, such as with review of the substance of institution decisions on some issues, such as RPIs. Do you have any opinion of this expert role of this appeal court?
Well, there's some characterization of my views in there. I mean, the Federal Circuit actually I wrote a blog post in last week on this point. The Federal Circuit, I think, with the creation of the PTAB, the justification for the Federal Circuit, well, let me say it this way. The Federal Circuit is such a unique court, right? I mean, it's the only intermediate appellate federal court that has nationwide jurisdiction but limited subject matter jurisdiction. Every other intermediate federal appellate court is the opposite. Limited geographic jurisdiction, almost open-ended subject matter jurisdiction, except for patent cases. So it's very unique. So the justification for the Federal Circuit, or let me say it this way, the justification for a national patent court, the Federal Circuit judges will bristle, some of them will bristle and say, we're not a patent. Okay, but you have exclusive jurisdiction over appeals in patent cases. So whatever you want to call yourself. But the justification in the calls for a national patent court or the Federal Circuit have existed since the 1800s. I wrote a blog post on this on my blog in the last week. The justification for the National Patent Court has changed over time, but there have been calls for a national patent court for 150 years. And effectively, we got it, if you want to call the Federal Circuit a national patent court, we could call it that. Even the Federal Circuit judges, some of them bristle. We got it in 1982, but today, as compared to 82, we're in a very different state of the world. Yes, I guess ex parte re-exam started in 80, and then we had inter partes re-exam, and we had all these new procedures. But here where we are today, we have very much expanded authority at the Patent Office to review the validity of issued patents, as was pointed by the previous question. We didn't have that historically. We barely had it in 1982. The PTAB has significant authority to decide validity disputes. Not exclusive authority, as it turns out, Congress could have, but did not say that if you're going to challenge validity, you only can go to the PTAB. We have this kind of parallel proceeding, which is causing, I think, lots of problems actually. But let me add to that. We also had, I mentioned earlier in my presentation, the Federal Circuit, I think, was created in large part because the Supreme Court was not deciding patent cases. And Congress wanted, and patent practitioners wanted just national patent, uniform patent law applied across the nation, but actually just decide what patent law is. And by the way, make it better as well, strengthening patent laws compared to what the Supreme Court is deciding. But my point is today, the Supreme Court, now this term they haven't granted review in any patent cases. We're still waiting on, I think we're up to 4 maybe, calls for the views of the Solicitor General. You guys may know more about that than I do, but at any rate, we're still waiting on the solicitor, acting solicitor, or real solicitor at the U.S. solicitor to weigh in on these patent cases. The Supreme Court has not granted this term in any patent cases. But as you know, as well as I, the Supreme Court's been very active in patent cases in the last 10 to 15, maybe 15 years, but certainly the last 10 years. There was one term that had 6 patent cases. It's an unbelievably large number for the Supreme Court when it hears only about 82 cases on the merits every year. So the Supreme Court, compared to 82, it's much more active in these cases. So again, in both respects, I think it calls into question, well, then why do we have a Federal Circuit? If the PTAB is doing the work that wasn't done before, if the Federal Circuit's just deferring to the PTAB, if the Supreme Court's deciding national patent law, unlike it did around 1982 and before, so in both respects, now we have the Federal Circuit. Well, why do we have the Federal Circuit? I think, and I put in my blog post, I still think there's this argument, at least for expertise, where, and again, some of the Federal Circuit judges might bristle. Some of them certainly come to the court with no background in patent law or very limited background in patent law. Others have significant background, like Judge Chin, but they develop their expertise over time just because based on the sheer volume of cases as they do their work. So that even if they don't initially have expertise, the court as a whole has significant expertise in patent law. But do we need that, given the PTAB and given what the Supreme Court's been doing in patent cases? That's, I think, the question. Because I mentioned what the justification was for the Federal Circuit. The justification was not, we need an expert court. That was not the justification. And in fact, if you look at the calls for a national patent court over the last 150 years, the calls have never been, we need an expert court. It has been, we need patent cases decided quicker. That was one of the original justifications for a national patent court. We need validity and infringement determinations to apply nationwide. That was really the second call for a national patent court. But when the Supreme Court decided, I'm gonna throw this out, a professor term, non-mutual defensive collateral estoppel, everybody remembers that. But anyways, the Supreme Court decided once the patent's invalid in one circuit, it's invalid in all circuits. That ended that particular call for a national patent court. Then we ended up with the call that succeeded in creating the Federal Circuit, this idea that we need uniformity in patent law, not uniformity in patent validity and infringement determinations, but uniformity in patent law. That was the justification that succeeded in creating the Federal Circuit. Well, now if the Supreme Court is willing to and does decide patent cases when there's a significant dispute over what the law should be, do we need the Federal Circuit? So I think there's a real kind of, this is kind of an inflection moment for our thinking about the Federal Circuit itself. What is its role in the patent system?
Sounds like you're making a case for PTAB as the National Patent Court.
Well, I mean, PTAB does not have jurisdiction over infringement purposes, and then given the Constitution, I don't think it ever will. But interestingly enough, we have a small claims copyright board that's going to hear disputes over copyright infringement. So, and I know there have been calls for an administrative body to determine smaller patent cases. I don't think recently, but we did hear that. I don't know if it was five to 10 years ago. So who knows? Again, it's a matter of institutional choice. So it's up to the political branches of our government with consultation, hopefully with those that have stakes in the matter and have expertise to make those decisions.
That's great. That's a great, Professor. Well, we have one last question. Okay, you noted that the Supreme Court's refusal to hear patent cases and resolve circuit splits helped to drive the formation of the Federal Circuit. Was making review of patent case appeals from the circuits at the Supreme Court mandatory rather than discretionary? Any thoughts on what our system would be like today if that had been the approach to creating a national uniformity in patent law?
Well, interestingly enough, yeah, that's a great question, because what would we look like today if we did that? By the way, I don't think I never heard that discussed in all my reading of the different commissions. I never saw that discussed. The Supreme Court was always viewed as too busy. But what would it look like today? I think it would look like the Supreme Court's practice in the late 1800s, at least before 1891. So 1891 was the bellwether year in which Congress decided the Supreme Court did not have appellate jurisdiction, it had petition jurisdiction. Sort of like the PTAB'S jurisdiction, you have discretion to decide whether to take the case. It may be bounded in some ways. The Supreme Court's discretion, I think, is fairly unbounded. But prior to 1891, the Supreme Court had appellate jurisdiction. If you lost in a patent case, you had the right to have the Supreme Court hear your case. Well, what resulted? That was the problem. What was the problem back then in the calls for national patent court? It took too long to get your case decided. Why is that? Because the Supreme Court was overburdened with way too many cases. They just couldn't decide all the cases, and it would take. There was a report. It was a report much later, but by the Congressional Research Service reviewing the calls for a national patent court in the late 1800s, and they have some quotes there that indicate, you could wait 10 years to have your patent case decided, and then it was a 17-year term of your patent, and then you're in limbo for most of the term of your patent, and that was viewed as a big problem. Now, would we have that problem today? I don't know. I mean, because the proposal I think Judge Morgan proposed was just make the Supreme Court take patent cases and not any other type of case. Well, maybe that would work, but then if that were the case, yeah, we could do away with the Federal Circuit. But I can't imagine that Congress would do that. But we could think in hypotheticals. That's why I'm here.
Okay, thank you so much. Okay, I think that's it for the questions. Thank you again, Professor, for coming and talking to us. We really appreciate it. We learned a lot, and thank you for the slides. If you don't mind, we're going to post it on our website so people can look at them later. We also recorded this session, so we'll also put that on the website. We appreciate it. Thank you for being our inaugural speaker, and this is a great beginning. So we'll have you back when you do more of your studies. We're excited for you, and I hope your studies go very well. So,
well, thank you very much. Yeah, it's been an honor to be with you, and great questions. I really appreciate the feedback and challenging questions. And yeah, there's more work to be done for sure.
Thank you, Professor.
Okay.
All right, thank you everybody for coming. Have a wonderful weekend. All right, take good care of yourselves.